All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So we've got a little potpourri today, Phil. I'm going to talk about some cases from the 6th, 7th, and 8th circuits, not necessarily in that order, but for our viewers, just to remind everybody that we live in the 8th Circuit Court of Appeals here in Missouri. That also covers North Dakota, South Dakota, Nebraska, Minnesota, Iowa, and Arkansas, in addition to Missouri. The 7th Circuit, our listeners in both Illinois and Indiana, and in addition, Wisconsin are covered by the 7th Circuit. And those folks who live in Michigan, Ohio, Kentucky, and Tennessee are covered by the 6th Circuit. So the United States is broken up into these federal court circuits around the country. There are 11 of them, plus the DC Circuit, so a total of 12. And I'm going to talk about 3 of them today. The first one I want to talk about was decided yesterday by our own 8th Circuit Court of Appeals in a very significant case. I know we've talked a lot about in the past the issues of DE&I in the workplace and just how hard it is for employers to get things correct, and that they can't go into DE&I initiatives blindly. They really do need some legal guidance as they do this. And in this particular case, the 8th
Burt,
Circuit...
is this that gray area you're talking about?
This is definitely one of those gray areas that I'm talking about.
Okay.
So yesterday, the 8th Circuit affirmed the decision of a district court decision that granted summary judgment in favor of an employer after an employee was fired for what he claimed was a religious bias reason, because he called a Pride Month rainbow on the company's website an abomination. And in the lawsuit or in the decision, the 3-judge panel said that the former employee did not show that the company targeted his religious convictions. And it noted the company's finding that he ran afoul of a company ban on denigrating groups of people. Therefore, he violated a company policy. So what's significant about this is that the individual had responded to a company survey that he believed was anonymous, and he wrote in that survey, "It's an abomination to God. Rainbow is not meant to be displayed as a sign for sexual gender." But he also had shared his opinion publicly on a message board on the company's intranet, and that prompted the company to fire him for violating its diversity policy on top of other disciplinary issues. And he ended up suing the company back in May of 2022. Like I said, he lost at the trial court level. He has now lost at the Court of Appeals. And I think the case, again, really just illustrates, like you mentioned, Phil, this gray area where had he properly tied it to his religion and just made his statement on the anonymous survey, or even if he had made it publicly but tied it to his religion, he may have been okay. But here, he didn't tie it to his religion when he made his public statement on the company's intranet. So that he was fired for violating company policy, and the 8th Circuit upheld that decision. I wouldn't be surprised to see this case be taken all the way to the U.S. Supreme Court. We'll have to keep our eyes on that one. But once again, it illustrates that difficulty of DE&I efforts in the workplace in light of the Supreme Court's holding regarding the universities and their application process. The DE&I categories really can't be used as a preference for making employment-related, admissions decisions in those cases, but we could fairly read that into that you can't use that for making employment decisions.
Well, it and I think it really goes to show, when these types of things surface, and many of our members take and use employee opinion and engagement surveys. Many of our members have social forums and formats for employees to participate in. And all of those are great things to gain opinions and to have some expression from time to time as it relates to our culture. But in this case, this company appears to be serious about their culture, and that all groups of people are going to be welcome, and that no group of person is going to be attacked or allowed to, be under scrutiny, I think, by other workers in this case in an unfair way. And you have to get legal guidance, right? This is not one of those scenarios to where you can just haphazardly make a decision based on, small set of data. You're going to need to consider the impact of this as far reaching, particularly in today's time, because I think everyone has somebody willing to represent them to make a stink out of things.
That is certainly true.
Yeah.
That is certainly true. All right, well, let's shift gears real quickly, Phil. I want to talk about a case that also came down yesterday, but this time from the Sixth Circuit, and this is going back a few years, but the decision was just issued yesterday, and the Sixth Circuit upheld Biden's firing of Trump's top NLRB lawyer. You'll remember that on the show many years ago, I relayed that President Biden, on almost day one of his administration, fired the Trump-era NLRB General Counsel Peter Robb and replaced him with Peter Orr. And that was almost immediate. That firing has been upheld by the Fifth and Ninth Circuits, but the U.S. Supreme Court last month remanded the matter back down to the Fifth Circuit for reconsideration in light of the Chevron doctrine decision, which we've talked about extensively on that show. In this particular case, a construction company contested Biden's January 2021 removal of Robb, who had 10 months remaining in his 4-year term, after Orr, the new NLRB General Counsel under Biden, issued unfair labor practice complaints against this particular company. The company argued that Robb's removal was invalid, so the complaint from Orr was also invalid. The appeals court concluded that the U.S. Constitution gives the president the authority to remove those who assist him in carrying out his duties, and Biden's removal power of an executive officer is generally plenary, meaning that it really is without restriction. And so I think that this is really important in light of the upcoming presidential election, because a decision like this does have some precedential effect if by chance Trump would get elected and he wants to then turn around and remove the NLRB's current general counsel, Jennifer Abruzzo, who we've also talked about on this program often, and who is distinctly anti-employer. And if Trump were to be elected, I think this decision would give him some authority to say, yes, you could remove Jennifer Abruzzo on day one of your administration. Of course, if Vice President Harris gets elected, I would imagine that the current general counsel will continue in her role unabated.
Right. Well, that's interesting to see, but I think what I took out of that, Burt, was they pushed it back down. So this all occurred years ago before Chevron decision was made, and then in light of that, they pushed it back down and said reconsider based upon Chevron.
Well, the Supreme Court told the Fifth Circuit to reconsider, but yet this was a Sixth Circuit case that decided that the firing was lawful. And so it'll certainly end up on the Supreme Court's door again, and we'll have to see what the court does with this.
Yeah.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.